Welcome to my YouTube channel, Legal Information Law Insights. I am Advocate Mukund Mahajan. Today, we are going to discuss a topic that almost everyone thinks they understand, but in reality, the legal truth is quite different. The topic is nomination. Is it really important? Does it guarantee ownership of your assets? And where exactly is nomination recognized in law? Let's clear the confusion step by step. 1. Why nomination exists. The purpose of nomination is simple. When the owner of an asset passes away, the institution, whether it is a bank, a mutual fund, a company, or a housing society, needs to know who to hand over the asset to immediately. This avoids delays, prevents temporary disputes, and ensures that the money or property is not stuck in limbo. But here's the key point: in most cases, the nominee is merely a custodian or trustee. The Supreme Court has made it clear that the nominee's role is to receive the asset and hold it until the rightful heirs claim it. 2. Important court judgments you must know. Let's understand what the courts have said about nomination. Sarbati Devi vs. Usha Devi, AIR 1984 SC 346. The Supreme Court ruled that in the case of life insurance, the nominee does not become the owner of the policy amount. The nominee's job is only to receive the money, and then it becomes part of the deceased's estate, to be distributed according to succession laws. Shakti Yezdani and Andhra vs. Jayanand Jayant Salgaonkar and ORS. 2023. The Supreme Court held that nomination under Section 72 of the Companies Act or under the Depositories Act does not override inheritance laws. A nominee of shares or securities is not automatically the legal heir. Supreme Court Judgment, 14th December 2023. In a dispute over mutual funds and fixed deposits between two brothers, the court ruled that the nominee was only a temporary custodian. Since there was a valid will excluding him, the assets had to go to the beneficiaries named in the will. Allahabad High Court, May 2025. The court reiterated that a nominee is not the owner of the insurance payout; they are a trustee for the legal heirs. The proceeds form part of the estate of the deceased. 3. 2025 Judicial Update, Karnataka High Court ruling. A noteworthy case from 2025 is the Karnataka High Court's judgment in Neelavva at Neelavva vs. Chandravva and others. Here's what the court clarified. A nominee in an insurance policy is not the absolute owner of the proceeds if legal heirs come forward to claim. Even after the 2015 amendment introducing the concept of a beneficial nominee, personal succession laws prevail when heirs stake their claim. In this specific case, after the policyholder's death, the nominee, the mother, was only entitled to a 1/3 share, alongside the spouse and child, Class I heirs, each receiving 1/3 of the proceeds. This judgment strengthens the consistent position taken by courts: nomination does not override succession law. 4. Movable assets and nomination. Let's look at some practical areas where nomination is permitted. Bank accounts, FDs, RDs. Under the Banking Regulation Act, banks pay balances to the nominee after death. But legal heirs can still claim the amount in court. Shares and securities permitted under the Companies Act and Depositories Act. The nominee is added to company records, but legal heirs retain the right to challenge. Mutual funds. As per SABI regulations, the nominee receives the money, but ownership is again decided by succession laws. Life insurance. Under Section 39 of the Insurance Act, beneficial nominees, spouse, parents, children, have stronger rights, but even these rights can be contested by other legal heirs. Government schemes like PPF, NSC, SCSS, all allow nomination, but legal heirs' claims prevail under succession law. 5. Immovable property and nomination. Nomination is even more limited in immovable property. Cooperative housing societies, they allow nomination for flats. After death, the nominee becomes a member of the society. But ownership is governed by a will or succession, not nomination. Apartment ownership acts. In some states, nomination may be treated as ownership unless challenged. But this is not uniform across India. Freehold land or houses, there is no nomination provision under the Transfer of Property Act. Ownership passes only via a valid will or intestate succession. 6. Nominee versus legal heir, the core legal point. Across all judgments, one principle is clear. Nominee is not equal to legal heir. A nominee is appointed to help the institution hand over the asset smoothly. But the legal heirs can question and reclaim the asset. The nominee's rights are temporary and limited, they are answerable to the rightful heirs. The only partial exception beneficial nominees in life insurance, where stronger rights may be granted, but even then, these are not absolute. 7. Why nomination still matters. Despite all these limitations, nomination is still essential. Without nomination, your family may face long delays, additional documentation, legal battles. But remember, nomination is equal to temporary access and will is equal to final ownership. So, if you want your nominee to actually inherit, make a valid and registered will. Nomination ensures fast release from the institution. A will ensures rightful ownership as per your wishes. 8. Practical takeaway. Always register nominees for your bank accounts, mutual funds, insurance, shares, flats, etc. Always draft a clear, registered will to ensure proper distribution. Don't assume nomination alone gives ownership. Nomination without a will is only half protection. Thanks for watching this video. If you found it informative, please like, subscribe, and share your thoughts in the comments. Don't forget to hit the bell icon for more legal insights. I will meet you in the next video soon. Jai Hind. Jai Bharat.